Fox and Hounds reference piqued my interest in an otherwise somewhat dreary argument. So on something much more complex than we have before the court this morning, or this afternoon, excuse me. Your Honors, I'm here again on behalf of the appellant in what really started out as a garden variety landlord-tenant matter. My folks, and I have Dr. LeVay in the courtroom and also some folks from the law school that are here to observe the appellate arguments, I believe that in the same manner as this morning. And this started out, my client is a landlord of some property here in South Knoxville off of Redbud. Started off as a rather routine landlord-tenant matter where there was an initial sort of skirmish about detainer interest. There was a temporary restraining order that was obtained. And then there was essentially a lull in the case. And quite frankly and candidly, my co-counsel, Mr. Hirshhorn, who did the trial work, assumed that this matter was over. Sort of out of the blue, however, the appellees filed a verified countercomplaint alleging that the actions of another principal of our client, Ms. Lavelle, while she was the agent of PMC, were the proximate cause for the significant emotional distress that each of the appellees suffered, and this is a quote, as a result of the slanderous statements or communications under the TPPA Act that Ms. Lavelle made to others about them, including members of the Knoxville Police Department and other residents, and further alleged under oath that these statements were designed to tear down the reputation and good standing of the appellees in their respective communities. I think any reasonable practitioner that received those kind of verified allegations related to slanderous statements would be well within their right to do what Mr. Hirshhorn did, which is to file a petition under the TPPA, or as I've recently heard it characterized as the TIPA. And I know the court has dealt with this statute numerous times, and we're here once again on, I think, frankly, an issue of first impression. Because what happens is the TPPA petition, which is, we contend, a verified petition, is filed. There are 21 facts contained within that petition that go to the nature of the slanderous statements, which were completely and totally uncontroverted. And in fact, the only dispute contained within the record was counsel opposite appearing at the hearing and essentially saying there's nothing to see here defense, and these are not statements within the public domain or public concern, and therefore the TIPA or the TPPA does not apply. That is the whole sum of any response or opposition to the TPPA petition. In addition to the 21 statements, the following, and I want to quote them because I think they're important, statements of fact were uncontroverted. And again, we contend that they were verified. That the allegations related to in the verified countercomplaint were contrived as retaliation for PMC evicting the appellees and seeking a temporary restraining order. They were designed to harass and intimidate PMC and to chill its right to public participation in the form of a First Amendment free speech, the very essence of an anti-SLAPP claim, we contend. And finally, that the countercomplaint in this regard did constitute a strategic lawsuit against public participation. The trial court then held a hearing on the petition and seemed to be bothered, for lack of a more sophisticated term, about the condition of the record. The court seemed to be under the impression that my client was required at the trial court level to provide an affidavit or other evidence to support its claims. And I think in the abstract, perhaps in terms of best practices, that might be done. I think here, where you have, number one, the verified allegations contained within the counterclaim, stating, as I did, about the slanderous statements, and also I should add, asking for, I think, over $100,000 in compensatory damages, taken with the uncontroverted verified facts within the TPPA petition and the fact that there was no response filed. I don't think that is required under my understanding and interpretation of the statute in terms of the substance, the prima facie standard that the trial court can look to determine whether my client met the first burden. And indeed, that statute says may. Of course, the trial court may consider that type of evidence, but it doesn't have to. The court went on to look into the analysis and essentially said, well, since there's no specific statement, and somehow expected my client to be able to articulate what this statement, I mean, keep in mind, my clients deny that any of this occurred, but they can't control the allegations, the verified allegations of the appellees. The court seemed to be constrained by that in terms of not knowing exactly what the statement was, and then finally concluded, notwithstanding the fact that there are allegations that statements were made to tear down reputation and statements made to law enforcement, that somehow that did not come within the confines of the TPPA in terms of a public concern. We then filed this petition as our appeals were allowed to in terms of the denial of petition, and point out those issues to the court that in fact we feel like we've made the burden, the very low burden, and I would point out also to the court that Pragnell, of course, had not come down either for our side or the trial court in terms of the decision. We would ask the court, if there are no questions, we'd ask the court to reverse the decision of the trial court and to grant my clients their sanctions and fees as provided within the statute.
Help me here.
Yes, Your Honor.
What do you say was before the trial court that proved your prima facie case?
A couple of things, Your Honor. First and foremost, don't forget that the appellees had verified allegations contained within their counterclaim that I think standing alone would satisfy the prima facie burden within Pragnell, first of all. So if we just had those in a vacuum, I think that's enough. But we had more than that. We had those allegations. We also had the petition that was filed that we contend was verified, that was also uncontroverted, the 21 facts, including the critical facts that I just reiterated to the court. So I think those two things combined with the fact that there was no response other than to say, well, there's nothing to see here, Judge. These are not statements that we've made, and they admit in their briefing that they've made those statements, including statements to law enforcement, and at least the allegations, that doesn't come within the TPPA. I think all of that certainly is enough to overcome the burden where the court should have satisfied that component and then looked to the other side to see if they could satisfy their prima facie burden, Your Honor.
Okay. You still have your time for rebuttal.
Thank you, Your Honor.
Hear from the appellee.
Please, the court. My name is Gerald Becker from the Knox County Bar. At the outset, I wanted to advise the court that I rely heavily on the brief prepared by Emily Stoltz in my office, and I think that our brief covers all the arguments that we wish to raise in this case. The fundamental argument on our part, Your Honor, is the TPPA doesn't apply in this case. I mean, it's absolutely, as I said in my brief, absolutely irrelevant. The purpose of the TPPA, as I stated in my brief, is to encourage and safeguard the constitutional rights of persons to petition, to speak freely, to associate freely, and to participate in government to the fullest extent permitted by law, and at the same time protect the rights of persons to file meritorious lawsuits for demonstrable injury. As Mr. Rose said, this is as I said, actually, and he's repeating my words, this is a garden variety landlord-tenant dispute. To try to elevate this to some sort of a TPPA case is nonsensical. Nonsensical. There is nothing about the facts in this case that would call this statute into play. And I think the important thing, Your Honor, is that Mr. Hirschhorn had the opportunity to address these issues before the court, Chancellor Weaver, and on page 22 and page 23 and page 24 of our brief, we cite the exchange between the two of them. There are certain burdens that have to be met to show a prima facie case. And the court asked Mr. Hirschhorn, do you have any evidence you want to present today? His response was, I have no evidence. He went on to say, he said, well then, Mr. Hirschhorn, call your first witness. Your Honor, the statute does not require us to put on any evidence. I'm saying the judge said, do you have any other evidence? He said, no, Your Honor. The court said, are you relying on your affidavit? He said, yes. And then the court said to him, your verification is made upon information, knowledge, and belief. Is that correct or not? It is, Your Honor. Then the court says, next question, Mr. Hirschhorn, Would a statement made on the witness stand upon knowledge, information, belief be inadmissible evidence? His response was, no, Your Honor. The court says, in the end, that the court may base its decision on supporting and sworn affidavits stating admissible evidence upon which the liability or the defense is based and on other admissible evidence presented by the parties. The court said that was not admissible evidence that he raised with the verification. The court says you must first establish a prima facie case. You have done nothing to back up your complaint, which you call a slap action. Your Honor, I can go on further, but I think that Ms. Stoltz covered all the aspects in this case. Again, the gravamen of our responses, the statute is inapplicable, irrelevant, and has no basis or use in a landlord-tenant dispute. We ask the court to affirm the trial court.
Thank you. We'll hear from the appellant rebuttal.
Picking up on that last point, Your Honors, I agree that there was an interesting treatment in the brief, in the appellee's brief that was filed. But the problem is all those issues have been waived, and they've been waived other than the public concern element because no response was filed to the original petition. And the only argument that was made was essentially, again, there's nothing to see here because these are not matters of public concern. So I think all the other somewhat interesting arguments contained within the brief candidly are waived. A couple of points to bring up with regard to the evidence issue. My learned counsel opposite did not reference the court to other parts of the transcript where Mr. Hirschhorn indicated he would go get his client if needed. I think, frankly, if you read the entire transcript in the context of the analysis provided by the trial court, even if in-person testimony had been heard from a representative of the corporation, remember, I don't think it would have made any difference because, frankly, the court was going to deny or, as the court put it, dismiss the petition in any event. So I'd ask the court to look at the record in toto as opposed to just piecemeal. And then finally, about the verification element. Number one, this verification language, I think I've used that same language particularly for corporate entities that are legal fictions. I mean, there's no entity that can swear affirmatively through a human one thing or another. We all know how that works within the legal fiction world. I probably used that for 20 plus years in litigation without issue. By the way, there wasn't an issue with regard to the trial court granting a TRO based on the same verification and finding that the underlying support for the injunctive request use that same verification. And even if it did, the analysis or the cases that were put forth by the trial court do not square with the particular situation here. Again, even if we assume that these 21 facts were not verified, they still were uncontroverted. They still were uncontroverted. And Pragnell tells us what's the standard. It's a very low burden for prima facie evidence. It is essentially some quality proof that's out there to suggest that these things are actually going on. And the best evidence for that are not things from our side, but quite frankly, the admissions made in the allegations within the verified counter-complaint. We'd ask that you reverse. Thank you.
We thank counsel for both sides for your arguments and your briefs on this. Am I correct? We have some more law students here?
Yes, Your Honor.
Okay. Well, what we'll do is we'll adjourn court for today, and we'll hang around for students that want to talk and ask us some questions, as long as it's not about how we're going to decide the cases you've heard today. We'll do that. So if you would adjourn court until our next regularly scheduled docket. Well, I guess they'll adjourn court till Friday morning.
Okay. All rise. This Honorable Court of Tennessee is adjourned until Friday morning. Thank you.
Okay. Y'all are excused. Thanks. Okay, the students, you all want to kind of move up this way. If you want, you can come on up this side of the bar.
Judge, one of the most obvious things I told them earlier